Legal terms for lawyers, law students, and non-lawyers too. 4. In learning these common legal terms, you can execute your professional duties with confidence and your own expertise. While earning an advanced degree in legal studies is one way to improve your legal knowledge, here are some common legal terms for non-lawyers in a variety of industries to help you get a head start. Legal Bibliography Series, Episode 1. Legal Terms in Business. Action. An action is a lawsuit in which a party or parties sue one another. A cause of action is the basis of a lawsuit, such as fraud, breach of contract, or negligence. Alternative dispute resolution. Alternative dispute resolution, ADR, refers to the use of a neutral third party to assist in reaching a voluntary, consensual settlement and avoiding litigation through typically confidential arbitration or mediation. Articles of incorporation. These formal documents establish the existence of a corporation, such as an LLC, S Corp, or Incorporated, in the United States or Canada, filed with the Secretary of State. These documents detail critical business information, including the legal structure of the corporation for tax purposes. Civil law. This is a generic term for non-criminal law, as it applies to settling disputes between private citizens or organizations. Civil lawsuits might be about negligence, a breach of a contract, or a land dispute between neighbors. Civil liability is the responsibility for damages in a lawsuit, as opposed to criminal liability, which leaves parties open to punishment for a crime that could include jail or prison. Civil penalties are fines imposed by the government to enforce regulations, such as failure to obtain a permit or pay taxes on time. Contract. A contract is a binding agreement between two or more parties that creates rights and duties for each party that are enforceable by law. They often outline processes for decision-making and dispute resolution. Contracts can be written or oral, implied or expressed. In some cases, oral contracts have little standing in court. Common contracts include: first, sales, manufacturing, housing, asset purchase, sales, employment, consulting, franchise, service, or licensing agreements. Second, confidentiality and non-compete agreements. Third, business partnerships, operating agreements, or stock agreements. Damages. Damages are awarded to someone who has suffered an injury or loss as a result of an action by another party. There are many forms of damages, including economic, physical, and emotional. Compensatory damages are recovered for injury or economic loss, whereas punitive damages are awarded to punish a defendant for his or her actions, such as negligence. A well-known example of punitive damages involved a woman who spilled hot coffee on her lap. The jury, wanting to send a message to McDonald's, awarded the plaintiff nearly $3 million in punitive damages, although the amount was later lowered by a judge force majeure. This clause relieves the parties in a contract from fulfilling their obligations due to an unavoidable event or unforeseen circumstance that could not be reasonably anticipated or controlled. Fraud. Fraud is the intentional deceit of one party to deprive another party of his or her or its money, property, or rights. Injunction. An injunction is a court order compelling a party to act or to refrain from a certain act, under the threat of civil or criminal penalties. Liability. Liability is the legal responsibility for one's actions. Failure of a person or entity to meet their responsibilities under the law leaves that party vulnerable to lawsuits for any resulting damages. Strict liability means a party can still be found guilty of an offense, even without any intent to harm. Malfeasance. Malfeasance refers to the act of doing something illegal or morally wrong, including dishonesty and abuse of authority by a person or business. Natural person. In the lawsuit, a natural person refers to a human being as a party, as opposed to a corporation. Negligence. Negligence refers to carelessness, or the failure to act in a way that a reasonable or prudent person would do in the same given circumstances. Negligence is different from intentional wrongs, such as assault or trespassing, but can still cause serious physical, emotional, or financial harm. Nonfeasance. Nonfeasance is the failure to act when action is legally required. Shareholder agreement. This is a type of contract that determines the rights of shareholders and defines when and how they can exercise their rights, including the right to transfer shares, right of first refusal, or redemption upon death or disability. Tort. A tort is an illegal act in which an injury occurs to another, whether intentional or accidental. Tort laws protect individuals from civil wrongs caused by individuals or by businesses, such as in the McDonald's example above. Assumption of risk. Defense against people who voluntarily expose themselves to a risk of harm, suffer an injury, and then sue. Asset. Property that has value. Attachment. Lawful seizure of a debtor's property prior to a judgment. Bankruptcy. Federal procedure relieving a debtor from his or her debts once the debtor is found to be insolvent. Liabilities greater than assets. Covenant. Written promise or obligation, part of a lease listing rights and duties of landlord and tenant, a promise made by a grantor in a warranty deed. Heir. One who inherits property according to his or her relationship to the deceased. Merger. The joining of two corporations to form a new one. Merchant. One dealing regularly in the sale of goods or having a specialized knowledge of goods. Negotiable. Legally transferable from one person to another. Legacy. Gift of personal property in a will,